every one of you is doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be discussing on the topic Right to Constitutional Remedies or Panacea. Let's begin with an introduction. The right to constitutional remedies is enshrined in the Constitution of India, which safeguards the rights of an individual and is equally pivotal for justice in the society. It empowers the citizens of the country to seek redressal in case their fundamental rights are violated. Constitutional remedies means the legal mechanism as provided by the Constitution of India to protect the fundamental rights. The constitutional remedies are very much significant in its form as they uphold the idea of rule of law, ensures accountability and preserve the liberties of an individual. The provisions relating to constitutional remedies are mentioned under Article 32 and 226 of the Indian Constitution. Now, let's throw some views on what are the constitutional provisions. Article 32 of the Constitution of India is considered as the cornerstone of the democratic setup of the nation. In a very landmark case of I.R. Coelho versus State of Tamil Nadu, that is of the year 2007, the Supreme Court declared Article 32 as the heart and soul of the Constitution. Also, it is because of this article the Supreme Court is declared as the protector and guarantor of fundamental rights. Clause 1 of the Article 32 gives the right to move to the Supreme Court in case of any infringement of fundamental rights. Clause 2 provides that during the enforcement of fundamental rights, the Supreme Court shall have all the powers to issue any directions or orders or writs. There are 5 types of writs which the courts can issue, namely writ of habeas corpus, writ of mandamus, writ of certiorari, writ of prohibition and writ of quo warranto. Clause 3 provides that the Parliament, by making a law, can empower any other court to exercise the powers given to the Supreme Court under Clause 1 and 2, who can act within its local limits of jurisdiction. Clause 4 provides that the right guaranteed under Article 32 cannot be suspended unless it is provided as per the provisions of the Constitution. As the right to move to the Supreme Court is given under Article 32, similarly, at the same time, the right to move to the High Court for the enforcement of fundamental rights is mentioned under Article 226 of the Constitution. Article 226 also provides for the same writs as mentioned under Article 32, but however, there is a difference between these two provisions. The difference between Article 32 and Article 226 lies in the Constitution itself. The difference between Article 32 and Article 226 lies in the Constitution itself. Point number 1. One of the most significant difference between the two is that Article 32 is a fundamental right and Article 226 is a constitutional right. Point number 2. Article 32 has a narrower scope because it is applicable only in case of infringement of fundamental rights. But on the other side, Article 226 is comparatively wider as it is applicable not only in the cases of infringement of fundamental rights, but also in case of infringement of any other legal right. Point number 3. As far as the suspension of writ jurisdiction is concerned, Article 32 can be suspended in the cases where an emergency has been declared by the President, but Article 226 can never be suspended on any ground or under any conditions. Point number 4. Article 32 empowers the Supreme Court of India to issue writs all over India, thereby having wide territorial jurisdiction, whereas on the other side, Article 226 empowers the High Court to issue writs only in its local jurisdiction, thereby leading to comparatively narrower territorial jurisdiction. Article 32 itself is a fundamental right, so it can be refused by the Supreme Court, whilst under Article 226, the powers under high courts or the powers with the high courts are discretionary and at the same can be even refused by the high courts. Now, these were the points of differences, and next we will be discussing the types of writs as given under the Constitution of India. The Constitution of India, whether under Article 32 or under Article 226, provides following 5 types of writs. Let's start with the first one, that is writ of habeas corpus. The meaning and objective. The literal meaning of this writ is you may have the body or produce the body. The writ is issued for releasing an individual who is illegally detained. The writ is usually in the form of an order issued by the court calling upon the person by whom the other person is detained to let the court know about the grounds of detention. If the detention is found to be without any legal cause or justification, the illegally detained person is released. The prime object of this writ is to provide quick and immediate relief for the release of the person who is unlawfully detained. Now, the question is as to who can apply for this writ. The basic rule is that an application has to be made by the person who is illegally detained, but in certain circumstances an application can also be made by any person on behalf of the prisoner. This writ is also known as the Great Writ. It was just deemed as summons with the force of order of court to determine whether the custodian has the lawful authority to detain the prisoner or not. Further, it is pertinent to note here that the writ of habeas corpus has certain limitations. The writ is technically only a procedural remedy as it releases a person who is under illegal detention, but as such does not protect other rights such as the assurance of fair trial. Now, on what grounds this writ of habeas corpus can be issued? The writ will only lie if the power of detention vested in an authority was exercised malified or is done with ulterior motive. Now, let us talk about the important case laws. Additional District Magistrate of Jabalpur versus Shivkant Shukla, AIR 1976 Supreme Court. This case is also known as habeas corpus case, and it is based on the grounds of viability of this writ. The entire case revolves around the situation when emergency was proclaimed, and the question raised was whether the writ of habeas corpus is maintainable or not. The court held that during emergency all the writs are to be suspended. This decision of the court was taken as the darkest day of the Indian history. Sunil Batra versus Delhi Administration, AIR 1979. The court in this case held that the writ of habeas corpus can be issued not only for releasing the person who is illegally detained, but also for protecting the prisoners from inhuman and barbarous treatment. Coming to the next writ, that is writ of mandamus. Let's discuss the meaning and objective. The word mandamus is a Latin word which means we command. This writ is in a form of an order from a superior court to a lower court or any tribunal or any public authority asking the latter to perform its duty which it is bound to perform. This writ is primarily issued to secure the performance of public duties. This writ is basically issued to public officer commanding him to perform his public duties, but which he has failed to do so. The main objective of this writ is to make government machinery function properly and effectively. The writ of mandamus was first used by English courts in early 17th century. The remedy of mandamus is available through the opinion of court, statutes and rules of the court itself. Now, who can apply this writ? This writ can be applied by any member of the society whosoever finds any public official failing to perform his duties. Now, what can be the grounds on which this writ can be issued? The writ of mandamus can be issued on the following grounds. The right must be recognized by law. Next, there must have been an infringement of right of petitioner. The petitioner must have demanded the performance of duty, but there was non-performance. There was an absence of any other alternate remedy. The petitioner can show that the public official is bound to do the duty as authorized to him. On the date of petition, the right must be subsisting. And last, the writ of mandamus is not issued for any anticipatory injury. Circumstances where the court can definitely refuse to issue this writ of mandamus: when the right of petitioner has lapsed. Number 2, the duty had already been fulfilled against which the writ is to be issued. Number 3, the writ cannot be granted against the president or the governor of a state. Number 4, writ cannot be issued against any private entity except where the state is involved as a private party. Some of the case laws, that is CoL1-L versus Union of India. The Supreme Court held that the writ of mandamus can lie against a private individual if he has colluded with the public authority. Another case, Rashid Ahmed versus Municipal Board. It was held by the court that an alternative remedy cannot be an absolute bar against the issuance of this writ. Another case, SP Gupta versus Union of India. It was held that the writ of mandamus cannot be issued against the president, and also in the case of CG Govindan and others versus State of Gujarat, the writ of mandamus was refused to be issued against the governor. Now, let's talk about the third writ, that is writ of prohibition. The meaning and its objective. The writ of prohibition means to forbid or to prevent. This writ is as old as a common law. It is only available during the pendency of the proceedings and is not an often issued writ. It is an extraordinary remedy by which the Supreme Court can direct an inferior court or tribunal or a quasi-judicial body to stop them from deciding upon a case because of lack of jurisdiction. If the court or tribunal lacks the jurisdiction and still adjudicates the case, it will be considered invalid because it will be the excess of sanctioning of law. The rigidity of writ has liberalized over time and may also be issued on grounds of natural justice against anybody. Grounds on which this writ of prohibition can be issued. Number 1, the inferior court or tribunal has overstepped its jurisdiction. Number 2, the court or tribunal is acting against natural justice. Number 3, unconstitutionality of any statute. And number 4, the violation of the fundamental rights of the Constitution. Now, let's discuss some of the important judgments relating to writ of prohibition. In the case of East India Commercial Company Limited versus Collector of Customs, this writ was passed directing an inferior tribunal barring it from adjudicating on the ground that the proceedings was without or excess of the jurisdiction. In another case of Bridge Khandalwal versus Union of India of the year 1975, the Delhi High Court refused to issue a prohibition against the central government from its involvement in a boundary dispute agreement with Sri Lanka, stating that there is no bar on the government from performing any executive or administrative duties. In 1967, another case, that is S. Govind Menon versus Union of India, the court held that the writ of prohibition can be issued in both the circumstances of excess jurisdiction as well as absence of jurisdiction. In 1955 case of Hari Vishnu versus Syed Ahmad Ishaq, the case established a distinction between certiorari and prohibition writ. the writ of prohibition can only be filed during pendency of proceedings. Now, let us talk over another writ, that is writ of certiorari, its meaning and objective. The writ of certiorari is the writ which is issued by superior court, that is High Court or the Supreme Court, to the inferior court or tribunal or body exercising judicial or quasi-judicial functions to remove the proceedings from such court, tribunal or body for examining the legality of the proceedings. If the order of the court is found to be illegal, then the Supreme Court or any superior court may demolish it. Whenever any body of persons having legal authority to determine the questions affecting rights of subjects having the duty to act judicially acts in excess of their legal authority, certiorari may lie to quash a decision that goes beyond the jurisdiction. The main object of the writ of certiorari is to keep the inferior courts or tribunals or bodies exercising judicial or quasi-judicial functions within their limits of jurisdiction as assigned to them by the law, and also another object is to prevent them from acting in excess of their jurisdiction. The question is as to who may apply this writ of certiorari. Generally, the person whose legal right has been invaded may apply for certiorari. Thus, the person aggrieved by the order may apply for it. However, if the matter to be reviewed is the one which affects the people generally, an individual citizen may ordinarily invoke the remedy of certiorari, as may such private citizen who suffers particular injury by the reason of judgment or order in excess of jurisdiction. The real test is whether the petitioner has been aggrieved by the order complained of or not. If the test is satisfied, even a form or noun statutory body may also apply for the writ of certiorari. Second question comes, against whom this writ can be applied? The writ of certiorari lies against an inferior court or tribunal or body which has been exercising the judicial or quasi-judicial functions. Now, what are the grounds for issuing the writ of certiorari? The writ of certiorari lies in the cases where inferior courts or tribunal or body exercising judicial or quasi-judicial functions acts without jurisdiction or acts in excess of jurisdiction or has abused its jurisdiction or has failed to exercise its jurisdiction. Next, where there is error of law apparent on the face of record, certiorari may definitely be issued. Therefore, if the decision of any inferior court or tribunal or body exercising judicial or quasi-judicial functions is vitiated by an error on the face of record, writ of certiorari may be issued to quash it. In such a condition, certiorari will lie even if inferior court or tribunal or body exercising judicial or quasi-judicial functions has acted within its jurisdiction. And for this purpose, error must be an error of law. Next point, where a judicial or quasi-judicial authority acts in violation of the principles of natural justice, writ of certiorari will lie. The court or tribunal or body exercising judicial or quasi-judicial functions are required to observe the principles of natural justice while discharging their functions. The observance of these principles of natural justice is the fundamental to the discharge of not only judicial functions but also to the discharge of any quasi-judicial functions. Now, let us talk upon the essential conditions for the issuance of writ of certiorari. Point number 1. The writ of certiorari lies against judicial or quasi-judicial acts of the judicial or quasi-judicial authorities, and it does not lie against purely ministerial acts of any such authority. The court or tribunal whose order is sought to be quashed by certiorari must be inferior to the court before which the application for certiorari has been presented. Next, the inferior court or tribunal must be within the jurisdiction of the superior court. Another question comes is when this writ of certiorari will not lie. Certiorari cannot be issued to quash an act or ordinance on the ground that it is unconstitutional or void. In such a condition, the proper remedy is the suit for declaration that the act or ordinance is constitutionally not valid. Where the adequate statutory remedy is available, the court may refuse to issue the writ of certiorari in case the application for writ of certiorari is presented before the superior court without first resorting to the remedies. Now, some case laws on writ of certiorari. In Surya Dev Rai versus Ramchandra Rai, the court held that certiorari under Article 226 is issued by the High Court when the subordinate court is found to have acted without jurisdiction by assuming jurisdiction where none exists, in excess of its jurisdiction by overstepping or crossing the limits of jurisdiction, and then third, acting in flagrant disregard of law or the rules of procedure or acting in violation of principles of natural justice. Another landmark case, that is Rupa Ashokhura versus Ashokhura, the court held that the writ of certiorari to call for records and examine the same for passing appropriate orders is issued by the superior court to an inferior court which certifies its record for the examination. Now, at this point of discussion, it is very pertinent to understand as to what is the difference between writ of prohibition and writ of certiorari. Writ of prohibition is issued before the proceedings are completed, while the writ of certiorari is issued after the decision is given by the court or tribunal. They are issued at different stages of the proceedings. A writ of prohibition will lie when proceedings are to any extent pending, and the writ of certiorari will apply for quashing after they have terminated in a final decision. Now, let us come to the last writ, that is writ of quo warranto. The meaning and its objective. The literal meaning of quo warranto is by what authority. By this writ, a person who occupies or usurps an independent substantive office is asked to show by what authority he claims that post. The writ of quo warranto is issued by the courts against a private person when he assumes an office on which he has no right. The power to issue this writ is discretionary on the courts, and therefore nobody can demand that the court is bound to issue this writ. There are certain conditions for issuing this writ of quo warranto. Number 1, the office which has been wrongfully assumed by the private person is a public office. Number 2, the office was created by the constitution or by any other statute. Number 3, the nature of duties which arises from the office is public. Number 4, the term of office must be of permanent nature and it should not be terminable at any person's or authority's pleasure. Number 5, the person against whom the writ is sought to be issued is in actual possession of the office and is using such office. And number 6, this writ can also be issued in those cases where a person was entitled to hold the office earlier, but after getting disqualified he is still in possession of the office. Now, who can apply for this writ? In case of quo warranto, there is an exception to the general rule that only a person who is individually aggrieved can apply for the issue of writ under Article 32 or 226. In the case of the petition of quo warranto, the petitioner does not necessarily seek to enforce his own right, but challenges the right of respondent to hold the public office. Any person, whether or not his any fundamental right or any other legal right is violated, may apply for the issuance of quo warranto at the instance of acting bona fide for the society. When can this writ be refused? It is never issued as a matter of course. This writ is a discretionary remedy. Consequently, the court may grant or refuse according to the facts and circumstances of the case. The court may refuse to issue quo warranto where it would be vexatious or futile. It may be refused if the petitioner has alternative remedy under the statute, but the existence of alternative remedy is not an absolute bar. Some case laws on writ of quo warranto. In the University of Mysore versus Govind Rao, the court observed that the procedure of quo warranto confers jurisdiction on the court to call upon the person holding an independent substantive public office or liberty to show by what right he holds the said office. Another case, that is in Haribansh Lal versus Sahudev Prasad Meheto, the Supreme Court made it very clear that the writ of quo warranto can only be issued when the appointment is contrary to the statutory rules. This writ will lie only when the appointment is contrary to the statutory provisions. That was all about the writs. Now let's conclude the topic. The Constitution of India has provided the power to issue writs to the Supreme Court under Article 32 and to the High Courts under Article 226. These writs are a command which is given by the courts for performance of an act to the public authority which has a duty to perform it. There are 5 types of writs which we have already discussed, that is writ of habeas corpus, mandamus, certiorari, quo warranto and prohibition, and all these writs are an effective method of enforcing the rights of people and to compel the authorities to fulfill the duties which are bound to perform under the law. These writs have played a key role in enforcing the rights of the people and have also improved the scope of power of judicial review of the courts. Thank you everyone for your time and attention. It was a pleasure explaining you about different types of writs as envisaged in the Constitution of India. We have discussed almost the entire topic and I hope that the listeners have understood it. Stay safe, stay healthy. God bless you. Take care.